Good morning, everyone. Irit and Ronit, thank you for inviting me to speak. In this presentation, I'd like to present some recent trends and case law that will hopefully shed light on the legal significance of the working definition. As Professor Porat said, it's not legally binding, but I do think it's legally significant from an interpretation perspective. So these are the main questions that I'll try to answer during our short time. First, what is considered anti-Semitism from a legal perspective, meaning which kinds of anti-Semitic behaviors are considered unlawful? And following that, what are what we consider to be the new forms of anti-Semitism, whether they are prohibited under the law? And finally, does the working definition of anti-Semitism have any legal significance? So in order to answer these questions, let's establish a basis for the discussion, and I'll run through the existing recognized categories that are relevant when we approach anti-Semitism from a legal perspective. So quickly, the first category would be anti-discrimination laws, and broadly speaking, it is the restriction of a person's access to services, education, or employment on the basis of his or her belonging to a certain group based on prohibited characteristics that the law recognizes. So in our case, this of course would be discriminating against a person because he is or perceived to be Jewish. The second category is what is widely known as hate speech, which is a criminal prohibition in national penal codes against inciting to hatred or to violence. And the next two subcategories, which are especially relevant and can also be considered as types of hate speech, are the denial of the Holocaust, its justification or gross trivialization, as well as prohibiting Nazi symbols and propaganda. And another category we would look for is the desecration of graves and memorial sites. And lastly, any offenses that are carried out with a hate bias motivation, or which simply, and easier to prove, target a person based on their perceived or actual belonging to a certain group, or what is known as hate crimes. And these offenses for which enhanced penalties would apply are also, of course, relevant and should be applied to anti-Semitic hate crimes. But what we have seen during the past 2 decades, besides anti-Semitic events which would correspond to these legal categories, is a different type of behavior, which is a shift in anti-Semitic discourse, which we've touched on already. Okay, so in the early 2000s, we start seeing slogans and demonstrations across Europe and chants like "Death to Israel." And we also see cartoons and newspapers on the internet that instead of saying things like "dirty Jew," people were finding out that you could more easily say "dirty Zionist." So this ambiguity was well served. Again, because instead of saying "death to the Jews," which one was not allowed to say, you could more now safely say "death to Israel," which Eliza talked about. So this is a way, arguably, to transfer your anti-Semitic feelings onto a more socially and legally accepted object, which is the State of Israel. And this is where it gets tricky. And this is where basically the crux of the matter is right now, in trying to find a way to unmask this anti-Semitic sentiment, which is at times at the basis of extreme anti-Israeli rhetoric. So when we try to define when speech or behavior is merely political speech, merely critical of Israeli policies, and when it does cross the line to what we know as anti-Semitism. And this is where the working definition of anti-Semitism comes in. So thankfully, Professor Poat has already given us a good basis, so I won't get into the specifics of the definition again. I'll only highlight just a few parts of it that will be relevant to the next cases I'll be talking about. So the definition includes several examples, and importantly, this one example at the top, manifestations might include the targeting of the state of Israel, conceived as a Jewish collectivity. And then it goes on to say, however, criticism of Israel, similar to that leveled against any other country, cannot be regarded as anti-Semitic. So, meaning that the mere fact that rhetoric is targeting a state rather than a person or a group, which is recognized under national penal codes, doesn't mean in and of itself that the rhetoric is not anti-Semitic. And on the other hand, the very fact that you are harshly critical of Israeli policies does not in and of itself constitute anti-Semitism. And this is a very important point because a prevalent criticism of the definition is to say that it aims to silence any criticism against Israel. And that is an easy point to counter-argue because the definition itself preemptively states this, that criticism of Israel similar to that leveled against any other country cannot be regarded as anti-Semitic. And of course, it is defined as non-legally binding. It's not a legal definition of anti-Semitism. And the working definition itself states that anti-Semitic acts are criminal when they are so defined by law. So the definition itself does not presume to create any new prohibitions. But what I would offer is that it is not devoid of legal significance, and this is because of the legal lacuna or gap in the law that hasn't yet made clear how to address hate speech, which ostensibly targets a state rather than a person or group, but really, in the process, has an effect of inciting hatred against Jews living in that state. And the relevant question is, what kind of language are you using when you are criticizing Israel? So just to drive the point home and make this as clear as possible, when you criticize Israel and its policies, this is not anti-Semitic. But when you do so using language or imagery that uses anti-Semitic motifs, it is anti-Semitic. Also, when you dehumanize, delegitimize, or use double standards, the 3Ds, this is also anti-Semitic. Are you comparing the IDF soldiers with Nazis? Are you using anti-Semitic blood libel motifs? Are you using classic anti-Semitic tropes in your criticism of Israel? So now I want to quickly present, because time is short, 4 different court cases that will give us an indication of a trend, I think, in this regard. And it will help us show the importance of knowing how to differentiate between legitimate and illegitimate expressions. So this is a case from 2015. In our circles, we've talked about it quite a bit. I'm sure most of you have already heard of it, but I think it clearly shows, I think, the conflation of criticism of Israel and what we really consider classic anti-Semitic speech. So in 2015, a Turkish-born Austrian resident posted this picture on Facebook with this caption. The caption reads, "I could have annihilated all the Jews in the world, but I left some of them alive, so you will know why I was killing them." This quote is wrongly attributed to Hitler, but that doesn't really matter in this context. This person posted these on Facebook in the context of criticizing the Protective Edge operation in Gaza, which took place the year before in 2014. So along with this, he also posted other statements like, "May God kill the entire Jewish state." And the authorities in Austria did open an investigation initially, and the case was brought before the prosecutor of the city of Linz. And after examining the case, the prosecutor announced that he chose not to prosecute since these posts were merely an expression of displeasure toward Israel. So just so we're clear, even though Australia does have robust criminal laws which prohibit Nazi glorification and symbols and justification of the Holocaust, and of course they have laws against incitement to hatred, in the prosecutor's professional opinion, a call to kill the Jews because they were said in the context of protesting Israeli government policies were seen as a legitimate criticism and not as anti-Semitic hate speech. So I think this really shows how a case was blatantly mischaracterized by authorities, and it highlights this gap in understanding, this time on the part of prosecutors, of when extreme anti-Israeli rhetoric is, in fact, anti-Semitic. So the prosecutor's statements received a very strong reaction worldwide. The Jewish community in Austria protested the decision by saying that Austrian judiciary was simply downplaying real anti-Semitism and was in effect legitimizing it. So this public outcry allegedly is what caused the senior prosecutor to take another look and reevaluate the decision. The case was reopened, prosecuted, and the man was convicted and sentenced to 8 months in prison. And I think this case is so striking because the person did use clear language this time. He didn't mask it, but only because of the context of protesting Israel, it was initially deemed legitimate. So moving on to the second case, I'll be brief about this because we're short on time. In July 2014, this time during the time of Protective Edge operation, a Jewish synagogue in Wuppertal near Dusseldorf was firebombed by Molotov cocktails. 3 Palestinian-born German residents were caught, and they confessed and said again that their motivation was to protest against Israeli actions in Gaza. The first court in Germany ruled in 2015 that the incident, of course, amounted to arson, but that since the perpetrator's motivation was to draw attention to the conflict with Israel, it deemed the attack not to be motivated by anti-Semitism. So the perpetrators were found guilty of arson, but not of an anti-Semitic attack. And this ruling was appealed but upheld in the higher court. So when we compare these rulings with the broad consensus of that year, then in nearly every report of monitoring agencies, this incident of firebombing was, of course, included as an act of anti-Semitic violence. So I think this case, in this case, we see the gap in understanding on the part of judiciary and on the connection between actions that aim to punish or incite hatred against Jewish people in Europe and protesting Israel, because this, of course, affected the Jewish community in Germany. So now I'm going to show another 2 cases that will show, I think, a different trend in another direction. The first one is from South Africa. It was given in 2017. It is the case of Bongani Masuku. He is a trade union leader who is associated with the Congress of South African Trade Unions. He's given many speeches across university campuses in South Africa. In 2009, Masuku spoke at Wits University and spoke against Zionism and Israel, and he threatened to make Zionists' lives a living hell. He said that Zionists should leave South Africa. He did not mention Jews. Masuku also said in front of South African college campuses, the following things are going to apply. Any South African family who sends his or her daughter to be part of the IDF must not blame us when something happens to them with immediate effect. So the Jewish community in South Africa merely demanded an apology, which Masuku refused to give. So this went to court. And one of the questions was whether South Africa's laws prohibiting hate speech could be applied to this kind of speech, which was supposedly directed at Zionists and didn't mention Jews. The judgment was given in July 2017. And we consider this an important ruling that actually makes the point, finally, of the working definition, because the judge declared that Masuku's statements did amount to incitement to hatred. And that even though he did not mention the word Jews, the judge understood his statements as absolutely and unequivocally pertaining to the Jews in South Africa. Another quote from the ruling reads, what was by the judge, what was done by Masuku was to distill detestation, enmity, ill will, and malevolence towards Jews in South Africa. It is distinct advocacy of hatred, nothing else. So again, this was considered a landmark case because it finally made this important linkage between anti-Zionist, anti-Israeli tirades and how they affect the feeling of safety of the Jewish communities living in these countries where these remarks are being made. So I'll end with this final case from Sweden, which was given this last September. And it originated from an event in 2017 during the time following Donald Trump's decision on the status of Jerusalem as the capital of Israel. In July of that year, Samir El-Rifai, an imam in Sweden, set in a demonstration against Israel, which was organized by the Swedish Palestinian Center. He said in Arabic, I'm finishing, Jews are the offspring of monkeys and swine. His film was filmed and published on social media, and he made this statement ostensibly as a response to Israel limiting prayer at the Al-Aqsa Mosque after 2 Israeli police officers were killed there. So the Jewish community in Sweden did file this to the police a few weeks later. And during the court case against him, the imam claimed that his comments, again, as other of the previous court cases, that his comments were aimed at the state of Israel and therefore should be deemed a legitimate criticism of Israel. The imam also claimed that during his upbringing, the word for Jew is synonymous with the Israeli regime. So the court dismissed both of these defenses, and that's important. The court found the imam's statement to be hate speech and not a legitimate critique of Israel, and that he was attacking Jewish people as a group in Sweden, and they are a protected group under Swedish law. So here again, the court was able to unmask these kinds of defenses and see the underlying anti-Semitism, even when it is said in the context of the Israeli-Palestinian conflict. Okay. Okay, so just to sum up, I think that these 4 court rulings show us that across courtrooms, this matter is being adjudicated, questions of what is anti-Semitic motivation, of whether claiming that your motivation was the Israeli-Palestinian conflict will exonerate you in any way, of whether rhetoric ostensibly targeting a country can be seen as affecting the sense of security of Jewish people. And this, I think, is the legal relevance of the working definition, to shed light on the difference between legitimate criticism and anti-Semitism, and to be able to interpret existing laws and apply them on the new anti-Semitism phenomena.